Good evening. Mr. Chairman and members of the Rhode Island House of Representatives Judiciary Committee, thank you very much for allowing me the opportunity to present testimony in opposition of Bills 7113 and 7164. My name is Dr. Sebastian Ramos, and I'm an obstetrician-gynecologist who also works at Women Memphis Hospital and practices here in Rhode Island. I am here to strongly oppose these two bills. Now more than ever, we must remember that facts are important. Any laws that affect the woman of Rhode Island should be rooted in evidence and fact. Viability is defined as the capacity for sustained survival outside a woman's uterus. It is a fact that when a pregnancy delivers before viability, whether by natural or induced labor, there are no medical interventions that can save the life of that extremely premature fetus. These proposed bills are simply not rooted in medical fact. This bill would allow prosecution of healthcare providers that do not provide resuscitation for fetuses deemed born alive after a failed abortion, regardless of gestational age, which would include way before viability. In Rhode Island, the majority of pregnancy terminations that occur in the second trimester are performed in the hospital by highly trained obstetrics and gynecologists, and nearly all of these procedures are performed for lethal fetal anomalies and serious medical conditions of the mother. Pregnancy complications such as preeclampsia and cardiac conditions may be so severe that induction before viability is the only medical intervention that can preserve a woman's health or save her life. Punishing providers for not resuscitating fetuses prior to viability is simply another way to place a barrier between women and the care they need and deserve. I have taken care of patients who have broken their water before viability. Nothing could have been done to save their tiny life. Many obstetricians, neonatologists, and pediatricians provide supportive and palliative care to neonates who cannot be saved and those that deliver from a medically induced pregnancy termination prior to viability. We oppose legislative mandates of life-sustaining care that is futile for neonates and that is not desired by parents or their physicians. It is illogical to require that extreme measures
Doctor,
be
what
taken.
if it is requested by the parent? As Representative Perez testified today, was his situation.
Would you like me to finish, or do you want me to answer your question?
No, I'd like you to answer the question,
sure.
and you'll have an opportunity to finish.
So it's like anything, any conversation between a physician and their patient, that's really what we're trying to advocate for. I think that's a complex conversation, and that parent and that physician need to have that complicated conversation as two individuals without having any law dictate what that conversation should be like. I can't speak to a event or a conversation between the representative and his physician, since I wasn't there, and I'm not going to make any assumptions about what that conversation was. But they are complicated, and they should be had. But I can't tell you what that particular conversation was, and so I can't, tell you any opinion about it. But they should be had, absolutely.
So you think it's appropriate at times for a child to be born before 23 weeks, and the parent the parent to request treatment, and for the doctor to refuse? I just want to make sure I understand your testimony.
No, so I'm not a neonatologist. That's important for me to dictate. I'm an obstetrician-gynecologist. Neonatologists are the specialists who have, these conversations once the fetus is born before viability. So that's a very important thing to note. I would say that, again, I am not going to speak. It sounds like this particular question is rooted on one individual's experience where no one else was there to witness. So I'm not going to comment on a hypothetical even, because that's really what I understand is we have conversations with patients about what we know. We are obviously we don't know everything, but what we know is that, fetuses before 23 weeks, survival rates are extremely, extremely, extremely low. And that conversation has to be had with the physician and the parent, and they can decide what they want to do, if they want comfort care, what they want to do. But that's an important conversation to have. And so, again, I would say that from my experience, I've never not seen that conversation happen. So it does seem a little bit like an outlier that the representative had that particular experience. But again, I'm not going to comment on that. From my experience, that's not something that happens often.
Okay.
We oppose legislative mandates of life-sustaining care that is futile to neonates and that is not desired by parents or their physicians. It is reprehensible to threaten healthcare providers with prosecution and jail time for not resuscitating neonates prior to viability. When these tragic circumstances occur, patients need access to sound, accurate medical information and have the freedom to exercise their best judgment in decision-making for themselves and their families and with their physicians. Their physicians should be free from the fear of criminal prosecution for honoring those decisions. This proposal is not based on medical science and is an unwise and unsafe political intrusion into the practice of medicine. It does not distinguish between a 12-week gestation and a 20-week gestation. And doctors shouldn't go to jail for doing what is right for their patient. On behalf of the patients we serve, we urge the House Judiciary Committee to reject these two bills. Thank you again for the opportunity to submit testimony.